When you know what you want for the future, you need the present to line up with your goals. UCF Online offers more than 100 fully online programs in healthcare, engineering, criminal justice, and more, so you can get to your future and beyond.
From the University of Louisville's Delphi Center for Teaching and Learning.
And the University of Central Florida's Center for Distributed Learning.
I'm Kelvin Thompson.
And I am Tom Cavanaugh.
And you are listening to Topcast, the Teaching Online podcast. Hey there, Tom.
Hey there, Kelvin. That's a good podcast. I like it.
I like it. Yeah, me too. I listen to it.
On occasion, yes.
On occasion, that's right. As a reminder, because we've kind of fallen off saying this recently, but we do say this is a collegial conversation about online, blended, digital, teaching and learning, conducted over a shared cup of coffee. So we're gonna do the thing.
The thing. We both have a cup of coffee in our respective little Zoom squares here.
Yeah.
I will tell you what's in my mug because it is not
Please.
thematically selected. I have a vanilla latte going today, a little afternoon treat. So that's what I have.
You have like a little frother there in your workspace?
It was it was a Keurig pod but it's surprisingly close without the froth. It's a cheap imitation of a vanilla latte.
Surprisingly latte-esque. Mm-hmm. Okay. Yeah, sure. Well, the coffee in my mug today, my first time I've used this, my spreadsheet shortcut mug, I had to get that. I thought that could be functionally helpful. I learn how to do key commands. My coffee today is a timely blend of two excellent single origin coffees, appropriate for spring, quote unquote, according to Sunagus Coffee Roasters here in Louisville. It is called Eclipse in honor of the April 2024 eclipse, viewable from many places in the U.S. And I'll say it's quite tasty. It's quite tasty. I wonder if you can find some kind of a thematic connection to the topic of the day.
I think that we're trying to navigate the darkness, perhaps, with the eclipse.
That's right.
We are approaching totality, I think, is what we're going to talk about today.
That's right. And, it's timely.
It is timely.
And
Absolutely.
There's two things brought together.
Oh, yeah. Okay.
Hey, there you go.
I get it. So do you want to tell our friends what we're talking about here?
Sure thing. So, Tom, you recently interviewed two return guests for an extended interview consistent with input received recently via our 2024 Topcast listener survey, an extended interview on a admittedly fairly U.S.-specific topic, but we're still hopeful that all of our listeners will find it instructive regardless of their location. You recently, Tom, interviewed Russ Poulin and Cheryl Dowd about some real utter darkness kinds of federal regulation pending here in the U.S. You want to say anything about that interview before I give the bio sketches of our two guests?
Well, some of it isn't just pending. Some of it is happening as of July 1st, and we're all having to sort of scramble. So, I mean, if there's ever a Topcast that you should listen to when it's actually released, not later, this is probably it, just because it is so timely.
That's good. Well, Russ and Cheryl. Russ Poulin is Executive Director of WCET, that is the WICHE Cooperative for Educational Technologies, and he is also Vice President for Technology Enhanced Education at WICHE, the Western Interstate Commission on Higher Education, one of the 4 regional higher education compacts in the United States. And Cheryl Dowd currently serves as WCET's Senior Director for Policy Innovations, and she directs the overall activities of WCET's State Authorization Network. SAN, S-A-N. Russ and Cheryl were with us twice previously, back in episode 112, Breaking News, Sarah and More Under Siege from 2022, and also way back in episode 58, when we were all more innocent and childlike. We call that episode Fun with Regulations, and that was released in January of 2020. And here we are today. We're on a theme. There are some technical terms used in this episode. Anything that you think is worth kind of mentioning at the beginning, Tom?
Yeah, Title IV, that is federal financial aid funding that comes, from Washington to the states. NC-SARA, which is the National Council for State Authorization Reciprocity Agreement, and they actually, I believe, are co-located with WCET out there in Colorado. Professional licensure programs, those are programs where in order to be in the profession, you have to have a license, whether it's like a teaching certification or something like that. And if you don't have it, you can't be in that profession. Those are things that we touch on. I don't know if there's anything else. We can maybe hit it on the back end if there is.
You do, I recall, I think you handle it in the interview, but you talk about clock hour versus credit hour. That's a thing.
That's a thing, yeah. Russ talks about that a little bit.
Yeah, and maybe it's worth saying you all recorded that interview in mid-April, and we're recording right now at the beginning of May, and the episode will release in mid-May. And you're going to hear phrases like just last week, and you could get disoriented. And some of the things that we talk about, hey, they could change by the time you're listening to this. So maybe this is a good time to look at the show notes, because we'll have the most up-to-date stuff right there.
Yeah, absolutely. As you mentioned, this is sort of timely, and things are moving, right? And so, like if you're listening to this a couple of months from when it's released, there may be updated information that you should be aware of.
That's right. Well, through the modern technological marvel that is podcast time travel, Tom, here is your interview with Russ and Cheryl.
Well, Russ and Cheryl, thank you so much for being on Topcast.
Great to be here.
Well, we have a lot to talk about today. If anybody's been paying attention to what's been going on in our nation's capital, they are aware that there is a lot of activity. So we thought this would be a really good time to bring both of you back. Both of you have been on the podcast before, to talk a little bit about just all of the various moving parts of the negotiated rulemaking process, what is happening, what has been proposed to happen, and what you think will happen. I think would be of real interest to the Topcast listeners. So maybe, Russ, you could kind of start with just like a one or two sentence for maybe people who aren't familiar with it. Like, what is negotiated rulemaking?
Yeah, happy to do that, and happy to have us here. That with rulemaking, that what Congress passes laws and the Department of Education can hold formal proceedings to add details to the enforcement of those laws. And so there's been a couple that have gone on in the last few years, one in early 2022 with rules that become effective on July 1st. And so those are a little bit more solid, and we'll talk a bit about those. There's also one that was earlier this year in 2024, where we're still waiting for those proposed rules to be published. So we'll talk about what we know about them at this time and where we think that those might go.
Great. Yeah. And it's a process I know that you've been involved with, like, directly in the past, but also sort of behind the scenes, nominating people to represent kind of our interests collectively in the negotiated rulemaking process, so that hopefully all voices are heard. All right, so one of the things that I kind of set up at the top was that there are some things that have happened that will be going into effect that we are all going to have to deal with. And the effective date is July 1st, 2024, right around the corner as we're recording this. So Cheryl, I wonder if maybe you could kind of start there and talk a little bit about what's expected of us, especially around kind of professional licensure, which seems to be the big one for July.
Sure. There are several issues that came out as final last October, but one of them that has an impact on a lot of these Topcast listeners today is around professional licensure, and it's increasing the responsibilities when an institution offers programs that lead to a license. There were regulations that became effective back in July 1 of 2020 that imposed notification structures so that you could inform people. There was transparency. And so what they've done is they've added responsibility when you're offering a program that leads to a license and you want the program approved for Title IV eligibility for financial aid. So what they've done is they've added in the program participation agreement, which is the contract between the institution and the Department of Ed, to offer Title IV. So there are things in this contract that an institution must do. One that they've added now is around professional licensure. And what they're asking is that the institution has to satisfy state educational requirements where the institution is located. Makes sense. But what is going to be a bit more of a challenge is satisfying state educational requirements in the state where the student is enrolled in distance education at time of initial enrollment. That's a mouthful. So what we're talking about is that out-of-state student, where they're located at time of initial enrollment, the institution has to satisfy the educational requirements in that state. Or the institution has the option to get an attestation from a student that they intend to seek employment in yet another state, and the institution meets it in that state. So we're talking about the North Carolina institution has a student in Mississippi, does not meet the state educational requirements in Mississippi. So you'd think they can't offer it there, but student says, oh, I'm going to live in Alabama and seek employment there instead. And North Carolina school says, sure, I get an attestation from you because we do meet the requirements in Alabama. So there's a little bit of flexibility that the department built in case a student is not going to be in a certain state permanently.
That's can I ask a quick question about that though? I mean, that is obviously just a huge administrative burden, because currently, as most people who deal with this are probably aware, is that you can say either we meet it, we don't meet it, or we have not determined. Now you're going to have to determine for every state whether or not you meet it, not just determine that, but notify the student or get an attestation that the student is not, eligible for that particular state, correct?
So you bring up a very good point. So that was just the tip of the iceberg, was this satisfying aspect in the PPA. The notifications didn't go away. The institution is still obligated to provide notifications. So the meets does not meet, but no longer are you required to address every state or territory and put it in one of three buckets. You now can determine that you don't want to serve a specific state. Let's say you're on the East Coast and it's a West Coast state, and you decide, well, we don't serve students in that state anyway. So you don't have to have a public notification about that state because you're not going to serve students in that state. Institutions have the ability to just simply indicate we don't serve students in certain states. And then they do not have to have a specific notification to that effect. But they also can't enroll students in that state. So that's still a part of it. And I think one of the most important things before we move on to some of the other issues, which we could talk about this all day, I know, is that just last week, the department released an electronic announcement, which gives a little bit of a reprieve to institutions that aren't quite ready for July 1. What the department indicated in this electronic announcement, that if an institution cannot meet the requirements by July 1 of 2024, they have a specific barrier to compliance. If they document that barrier, they explain why, have that documented. If there is a review by the department for your Title IV, so they've done a review. If you're able to show that documentation of the barrier, then they will consider that when they're doing the review. So it's a slight reprieve through January 1 of 25. So if an institution cannot meet on July 1 these new satisfaction requirements, and they can show the specific barrier that they have, let's say they couldn't communicate with the licensing board in that state, or some other type of barrier, they document that barrier, and they have until January 1 to make arrangements to be able to be in compliance.
My understanding is that the criteria for getting that extension are pretty narrow, though, aren't they?
Yes. So it's a specific barrier. You would have to note why you couldn't. It's not just the good faith effort that we saw back in 2011 with state authorization. It's a little bit more narrow than that. So you'd have to be able to identify what is the specific problem area of why you couldn't be compliant on July 1. Document that should the department do a review, and you can show why you weren't compliant on July 1.
So again, just a reminder for everybody listening or watching that we're talking about licensure right now. So like if you have a teacher education program, and those teachers need to be licensed. But what about like nursing that has a compact that involves multi-state? Is that covered?
That's a great question. And again, we could do an hour and a half on just this topic. So there is some flexibility in regard to licensing. It was not put in the regulation. The department in the preamble, which is that the answering of questions in the final rules when they provide the Federal Register announcement, they provided a response because actually we, among others, asked about, well, what about these compacts? And they indicated that that could be considered a form of licensure. But again, documentation is key because you'd have to show that the state where the student is located is a member to the agreement, the state where the institution is located is a member to the agreement, and that the student could have a license to license. So not just generally speaking, Ohio is a member to the new teacher mobility compact, as is Kentucky. It has to be licensed to license. So it has to have K2, so it has to be matching licenses to be able to have that be effective. So it's a documentation structure that you would have to develop to make that work. And so I say proceed with caution. It's not in regulation. It was only in the preamble, which is just guidance.
Wow. Okay. All right, so that's licensure, and that is in effect as of July 1, unless you get the extension. So everyone should be aware of that. And then we'll of course put some links, especially to WCET resources and analysis, and the state authorization network stuff that you've done, Cheryl. So all of it we'll put in our show notes for people to go deeper and to get more details. So that's kind of what is coming, definitely. Russ, I wonder if you can maybe start to touch on like what might be coming, especially in distance education, which is, the thing that's most important to our listeners. There was a lot of stuff that was proposed and that I'm sort of assuming is coming, but you tell me. And I wonder if you can kind of lay out the most important and things that we should be concerned about.
Yes, there was a lot discussed about distance education, and much of it was proposed by the department, some of it from the negotiators, and we do think that some part of this will be coming out, and the things that we're talking about they seem pretty keen on. So we did nominate Cheryl to be on the committee to talk about distance education, and especially for those that are not fully online institutions. And unfortunately, they didn't pick her. But what did come out of the discussions first was require attendance taking for all distance education courses. That they felt that institutions were not properly calculating what's called the last date of attendance for students who withdraw without notice. And as you know, what you're supposed to do is you're supposed to get the last academic activity by a student, such as that they took a test or they submitted a paper or they participated in an online discussion about the content for the course. And they felt that institutions weren't doing that properly, so they want you to be proactive in collecting all of that so that you can have that to display for those few students who fall out. Second, a whole other one was for institutions that use the clock hour financial aid. And so these are mostly practical programs like cosmetology or such, and that they will not be able to offer asynchronous courses anymore for clock hour programs. Now, I say that, now people will freak out. If you're offering through credit hour, this does not affect you. But for those practical programs that are using asynchronous, that they would, again, it's proposed, will probably be proposed that be ended.
So just to kind of underscore that, if you are using a credit hour system, which I think most of our listeners probably are, then you can still offer asynchronous online instruction, because that got some attention. I think when I read it the first time, I didn't quite catch the clock hour, credit hour distinction.
Yeah, and it certainly makes sense because people don't understand all these nuances about federal financial aid and how it's offered. And so, yes, credit hour will be fine, but there are lots of institutions that use clock hours. So finally, there are other distance education details, but there are two proposals about collecting additional data about distance education, especially about programs and students and probably student outcomes. And so those are probably the fuzziest, but there was a lot of interest about more data. And our big worry is that they just know how to use the data and how to interpret it once they get it.
Great. Okay. So clock hour, credit hour, last date of attendance, all of those things I think are worth folks digging into a little bit more. All right. So Cheryl, here's the big one, I think for a lot of us, state authorization. And the fact that it seems like NC SARA is being in many ways sort of gutted of its authority, at least in proposal. And I think it's got a lot of us concerned about the future of being able to offer online learning to students outside of our states, and that it will eventually, if what is proposed happens, and we'll go through the specific details with you in a second, but if what is proposed has happened, my biggest concern is that it's really going to turn online learning into the purview of the big, well-resourced schools that can afford a compliance infrastructure, and that the smaller schools are just not going to be able to compete, or they're just going to choose. We just don't have the resources to invest in this ability to get authorized in every state in the country. And some of the burden, if I remember what it was like pre-SARA, it's pretty high in some of these states to get authorized. So I wonder if you can kind of talk about what the proposals are and maybe what you think is going to happen.
Sure. So yes, I remember those days pre-SARA as well, and putting a budget together for, my institution to know what it would be. And we would have to identify certain states that we couldn't serve students because the costs would be, or the application structure, or the reporting structure, or all of the above, was so burdensome as compared to other states that we used to have the red, yellow, green system, of what, we would try to manage. And yes, so SARA brought about a uniformity of oversight that had not previously been available. So again, this is proposal language. We don't have the proposed rules yet. So what we have is, at this time, the language that was voted upon by the negotiators at that time, which we know because it did not reach consensus, meaning that it was not agreed upon by everyone at the table. That means the department gets to write the rules. So we don't know exactly what will be provided, but we can give you all what we think could be, or at least the ballpark. And why are we doing this? We're doing this because the department and some consumer protection advocates were concerned that some states have stronger protections and they're not able to enforce those because they're part of the reciprocity agreement, which points to the policies in the reciprocity agreement for purposes of oversight of interstate distance education. And so that was where this is coming from. So their interest is in trying to add to what would be parts of a reciprocity agreement, or beef it up, if you will, in terms of what would be required, or what a state would be able to impose outside of reciprocity.
Just a question on that. So, every state has chosen, except California, to join SARA. So the states have elected to do it. It kind of feels weird that outside advocacy groups and the federal government is stepping in to override what seems in many cases to be a states' rights choice.
You make a very good point, and it should be pointed out that in most states, it took new legislation signed by the governor to be part of the reciprocity agreement. And in states that didn't, it still was a governmental structure that provided for them to join the agreement, and states, it's a voluntary agreement. States may leave the agreement if they decide that that's not the way that they wish their folks in their states to be protected, that they want to be in a different structure. They may leave. They're not held to it. And then states approve the institutions to then participate on an annual basis. They review each institution to participate in the reciprocity agreement to offer activities in other states that are members to the agreement. So
go ahead, Cheryl.
So what the department was proposing here and then was voted on and did not reach consensus. I'm going to bring up two of the bigger things. The first was they wanted to have a limit of 500 students enrolled by the institution in a particular state. So you have University of X, has students in multiple states, but they have more than 500 in state Y. And so they would have to, because they would reach that threshold, if they would have to have the institution get particularly individually state authorization in that state. And so they could be part of reciprocity, but if they have more than 500 students in a particular state, they would have to get authorization directly from the state. Their thought is the larger footprint, the bigger risk. And so they wanted to pursue that structure. They also indicated during, we've heard them talk during the negotiated rulemaking and afterwards, that the 500 number is sort of arbitrary. And so it could be a different number. We don't know what activities that they're talking about. Is this just online education, distance education by online courses, or are we talking also about experiential learning that occurs in the state? So there are a lot of unknowns. It was put together in the second week of rulemaking as a proposal by negotiators and then put in the department's proposal the final week. So we don't know exactly what the parameters will be, other than they seem to be going for this larger footprint means bigger risk, and they want to do risk management.
So there were some questions that I've heard raised, including a great point by the executive director of Sarah at a conference that I was at recently, that there's no real definition of what a student is in that 500 number. And that 500 number, you're right, it seems very arbitrary. I heard 1,000 was proposed. I've heard 100 was proposed, and sort of 500 is where they settled. But is it FTE? Is it continuously enrolled? Is it enrolled in any given semester? And as you said, is it students who aren't even online but are doing a clinical in that or a practicum in that state at any given moment? What is a student is actually a fairly complex question, and this doesn't seem to address it at all.
No, the only thing that they got very specific on was 2 consecutive years. That's all. They added that to the language of the proposed language that they voted on. But other than that, they did not get specific to be able to help us understand who is a student, what activities we're talking about, who maintains the data so that we can be consistent, as far as, how did that 500 number get achieved or whatever number they arrive with. At one point, they were using NC SARA data to address things, which was kind of ironic. But there's a lot still unknown about how that would be managed. And I would hope that they move forward in that kind of way, that they put it in the regulation and not regulate by preamble, and put things there that, get lost in the shuffle rather than in regulation. So we'll see. There were other proposals about other risk management factors that perhaps could be used other than number of students. And we hope the department took that proposal from one of the negotiators to heart and considers those factors as well.
Russ, did you want to get in before we move on to the other stuff that's been proposed for Sarah?
Yeah, you had asked about the states, and if the states entered into this, and it has been noted by governors in some states and legislatures in some states that, but wait a second, the point you exactly made was that we passed this. This is how we decided to do this. And so we encourage institutions to make sure that their legislators and that their governors know that this is happening, because we're hearing that there may be, certainly from the National Council of State Legislatures, and probably from National Governors Association, maybe some interest from them in using their large voices in order to raise questions about why is this happening.
Great, thank you. Okay, Cheryl, state-specific laws. Like, I know this is an issue, like before Sarah, we were looking at different policies in different states because Florida has a very different, like in law, tuition refund policy for like date of withdrawal versus other states that we were talking. And it's like, in some ways, us complying with the other states' rules put us out of compliance with our own laws. And so Sarah was a way to address all of that, with this magic decoder ring that seems to be at risk now.
You make a good point. So what they proposed, the department proposed at the end there that was voted on that did not reach consensus, was the enforcement of certain state-specific laws. The first one they identified was applicable general purpose state laws, which is already part of what is in the reciprocity agreement that we all know as SARA, that those are enforceable. Those are the things that could be enforced upon any organization that is serving someone in a state. So that's already there. But what they added was compliance with state-specific laws related to closure. And this has a tie, and again, we could go down a rabbit hole on this one, to regulations that become effective July 1 of this year. And the closure laws was part of that participation agreement. But if you participate in reciprocity, you're in compliance with that. But what this will do is saying, even though you're an institution that participates in reciprocity, we are going to say that you are to comply with state closure laws of the states where you have students. And the examples they gave were tuition recovery funds, as you mentioned, surety bonds, teach out plans, and record retention. So they were saying that regardless of reciprocity, your institution would be responsible for complying with those state laws in those states.
Well, that's really only a situation if an institution is closing its doors, though, right?
Or programs. I know there was some discussion about programs, but we also, the situation too is how do you how do you show that they are complying with some of these things they want to see in advance? And then the other question that we have is some states don't have the ability to enforce state laws on out-of-state institutions for which there's no physical presence. So how would that work? How would they bring themselves under compliance of the state, under the oversight of the state, to be in compliance with those state laws, unless the state has a mechanism to bring them under their oversight?
How are, go ahead, Russ.
Yeah, and Tom, some of this actually comes in before you get to the closure, because let's say for tuition recovery funds that there are some states that what they will require is that every institution pay into a fund a portion of the tuition and fees that they collect in that state, and that you pay into that fund all the way along in case you ever close or in case somebody else closes is really what it's about. And so now they're starting to skim up that. Others use bonding. That's something where you post a bond, and so you would have to pay to do that. In most states, that they don't cover state institutions or public institutions, but in some states they were trying to ask for bonds from state institutions, and that ran into problems with some state institutions can't post a bond, and so you run into all sorts of interesting scenarios with that.
Wow. Okay. All right. That's a big kind of upending of the table of NC SARA if this goes into effect. So what do we think is coming next, Russ?
Okay, just back to the professional licensure. That remember that those go into effect July 1, and that we are expecting that there's going to be an additional question and answer about that coming out that will probably be published by the time this airs. And then, but for the proposed regs on distance education and state authorization, we expect the department to release written proposals for comment. Some people think that that'll come out in the next few months. Others are thinking maybe in the fall. Once it's released, that will be open for public comment, and we think people should comment about whether they're for or against these things. The department then responds to the comments, and then if a final regulation comes out before or by November 1st of this year, these regulations can go into effect as early as July 1st of next year. If they miss that deadline, then that all gets pushed back another year. We think that it's unlikely that they'll get anything out in the next few months, but some people seem to think that's going to happen. Also involved in all of this is kind of a murky future of possibilities regarding lawsuits. You may have heard that there's an election coming.
I was going to ask about both of those, actually, if you kind of indulge me. So the election, there's some speculation that the current administration, in anticipation of a possibility that there would be an administration change this November, and that are trying to get a lot of stuff done. And if they do, if they are able to get it by, November 1st, and then it goes into effect on July 1st, even if there is a change in the presidency, it still goes into effect, right? And it would have to go through another negotiated rulemaking process to get that changed. Is that true? It
still goes into effect. There is another thing called congressional review, that if the Republican Party in this case would have control of both the presidency and the House of Representatives, there are some ways to claw that back without having to go through negotiated rulemaking. If they do get it done, and that's why they really want to try to get it done, is that becomes a lot harder, and they may have to go through a negotiated rulemaking. So that is something. And if they don't make that November 1st, that a new Department of Education could slow walk or just end any of the work on this.
So regarding
we have an example of that, though. In 2016, the department released final regulations before they left office. So it just meant they missed the deadline. So they were to be coming in effect a year and a half later, and the rules had problems, but they had to use the rulemaking process to delay the rules to have another rulemaking. That delay got vacated and was another drama. But if they release the rules as final before they leave office, they're still on, ready to go through. Can the department do something about them? Sure. But they do get into the cycle.
Gotcha. Okay. And then as far as your reference to a lawsuit, I did hear a lobbyist recently kind of make a recommendation to institutions in general that, especially around these states' rights issues, that there probably is a case to be made to sue to stop this. Who would do that, and who would kind of take the lead on something like that? And you would sue the Federal Department of Education, I presume, right?
You want to take that, Cheryl?
Well, I think this looks a lot like, I don't know if you all remember when the first release of the state authorization regulations, they went for the whole thing, not just distance education, but distance education was ultimately vacated. So there will be aggrieved parties, and those aggrieved parties will sue the Department of Education. And, they'll sue it on a number of grounds, but the federalism ground is one of the things, and they may start to throw in other things about perhaps that there were issues with the Administrative Procedures Act that they didn't follow correctly. So we may see a number of issues get brought into a lawsuit. But I certainly see aggrieved parties such as institutions being able to sue the department over this.
It seems like it's also anti-competitive, where it's really just favoring the really large institutions that can afford to comply. For what it's worth, I don't know if that's breaking a law, but it just doesn't seem fair. All right, Cheryl, what do you think we should do besides maybe join a lawsuit if we're so inclined?
It is very important for the institution to start having conversations. So making sure that staff is understanding. So I know we work with a lot of compliance staff members who really need to keep their senior leadership informed. And so we suggest that they make sure and review their processes at their institution to see how they could be affected by these proposal languages. And certainly with in regard to the professional licensure, I hope they're already starting to work on some new processes to be available for this summer. But as far as what is coming out of this current rulemaking, start to look and see how you would be affected, how you as an institution would be effective, what would happen to your students, what would be the barriers, or if you're the other side of it, how does this help your students? So, of course, all of those things are important. So reviewing that, talking with your government relations folks at your institution, if you have that, and that would be helpful for them to be able to communicate with federal and state officials so that kind of understanding can be moving forward. We understand in talking to folks, sometimes they're unaware that this rulemaking has occurred and what the outcome was. So we want to make sure that the communication chain keeps moving forward. And then ultimately, as they've looked at this, they've had these conversations, start considering how you would provide a public comment to any proposed language should we see that this summer or through the fall. So institutions can start getting ready.
And if I may add to that, Tom, that the reasons that we're talking about elected officials is that it'll take a little bit for the proposed rules to get out. But if the department hears from senators or representatives at the U.S. level, that they'll know that, we better be addressing some of these questions. And then also, as we've talked about several times here, that legislators and governors are becoming more interested about, especially the reciprocity issues, and that they are working through, I mentioned National Council of State Legislatures, National Governors Association, that some of them get together, and we were hearing that from both parties, that there's questions being raised about this, that will be something that the department will take note of as well.
Great. That's really good advice from both of you. Thank you. Yeah, boy, it feels like don't blink because there's a lot going on and you don't want to miss the action. I don't know what we would do without the two of you and others like you and some of the other organizations that we're members of, kind of keeping track of all this and helping us to make sense and highlighting the most important things. I can't tell you how grateful we are. And thank you both so much for being on Topcast.
Thanks for having us. Really appreciate it.
Thank you. I think we owe you some coffee, Tom.
I think we do.
We'll take it. Thank you.
Well, Tom, that was your interview with Russ Poulin and Cheryl Dowd. Boy, they're a wealth of information.
They are. Actually, I said this, but I'm grateful that they are out there for us, watching this stuff, watching it with such detail, staying on top of it. I mean, there are others in the space, people like Jordan DiMaggio at SIA and Jarrett Cummings at EDUCAUSE, others that do a great job of watching the policy space. But honestly, anytime I really want to know, I go to Russ and Cheryl.
Yeah, there's a lot in there. I've listened to that interview, I'm going to tell you, multiple times.
So right? Have I. I've shared it internally at the university too, the raw video.
and I pick up some little nuance each time because there's just, it's dense. If you don't live in that, at the Russ and Cheryl level, you may miss something the first time through. I don't know if this helps, but I heard two big mountain peaks of topics you all, spent a lot of time on, but there's some little foothills and valleys of topics as well that are maybe not quite so urgent, but, things like data blast attendance, and Russ mentioned fuzzy data about distance education that might be required. And I'll just credit you, Tom. I thought your characterization of all of that as administratively burdensome was about the right take. Prohibitively so.
It's crazy. I keep kind of projecting my mind back into the pre-Sarah days. And, we had a director in our unit who it was almost all he did for a while was just trying to get into compliance in every single state. And if this happens and Sarah goes away, or at least is neutered to the effect that it's not really a reciprocity agreement anymore, then it's really going to favor the large institutions that can afford to stand up a compliance infrastructure that the rest of us can't, or if we can, maybe we're on the fortunate end, but a lot won't. And it's just going to drive students away from their local universities and their online programs there, or it's going to eliminate competition.
Yeah.
I have big problems with the anti-federalist sort of flavor of this, of central Washington government overruling the wishes of the states. As I think Cheryl or Russ, one of them, said that, a lot of states created new laws in order to become part of SARA, including Florida, where I sit. We had a new law that got signed by the governor so that we could join SARA. And now the federal government is coming in saying, no, you can't do that. I'm sure there will be lawsuits. This seems like the story's not written yet.
And yet, probably not the time to go, well, it's probably all going to be okay. There will be lawsuits. I mean, why should I worry about this? I mean, we should worry about this a little bit, not unhealthily so, but we should probably talk as we head toward the door, concrete actions. And again, we'll update the show notes if anything changes, but Tom, I'm going to guess you're going to say something about commenting, but what kind of concrete actions would you encourage our listeners to make?
Yeah, I mean, definitely if the window is open for us to provide public comment, then you should. Think back whenever it was, months and months ago, when the third-party services, the TPS stuff came out, there were over 1,100 comments. And that did have an effect. They backed off on a lot of the things that they had proposed, trying to create policy through blog posts as opposed to through the negotiated rulemaking process. So comment is definitely one of them. Talk to your institutional government affairs people. Make sure that they're read in on this, that they know what's going on. If they don't, then brief them and let them know sort of what's at stake, especially if you have a large and growing out-of-state online population. Feel like this sounds self-serving, but I don't mean it that way, but share this episode with them. Either a link to the YouTube video or just the podcast. I've done it internal to UCF. I've probably shared it with 6 or 8 people just to kind of say, look, if you want a half-hour briefing of like what the situation is, this is a really good overview. And it's because Russ and Cheryl do such a good job of boiling it down. So definitely engage those folks. We have a louder voice collectively than we do individually. And so I think if we're all saying the same things, maybe we can affect some sort of change. I won't hide my bias. I am very much opposed to what's been proposed. So I think it would be great if we could kind of mobilize to maybe stop it.
Well, I mean, as has been noted, perhaps, assuming positive intent, well-intentioned, consumer protection-oriented, but I think it would be really difficult for a reasonable person knowledgeable about online education in the United States to look at all this and not see it as a rather dire threat. So, dear listener, do something.
Yeah, and to your point, I mean, we all want consumer protection. Those laws exist and they should be enforced, but not by going backwards to the 1990s of online learning again.
That's right.
Yeah.
Well, Tom, you want to try to wrap us up and put this plane on the runway?
Yeah, let's. So we've previously encouraged staying informed and engaged when it comes to government regulation. It's not everybody's cup of tea, but it's important. We're all affected by it. But perhaps that's more important now than ever before, and especially for those of us who seek to foster high-quality online education. So please, everybody, do your part to ensure that your institutional leadership and elected government officials, policymakers, everyone understand the impact of these proposed changes.
Yeah, that's well said. That's it. That's right. Well, hey, let us know what you think about this longer, more vitamin-filled interview segment, dear listeners.
Fortified episode.
Fortified. That's a good one. Fortified. Maybe we'll do some more of those fuller-length things. Let us know about that. And until next time for Topcast, I'm Kelvin.
And I'm Tom.
See ya.